Concerned about an issue in your life? Need some legal direction? You've come to the right place. Welcome to 5-Minute Legal Insights, a podcast that features top lawyers from across the country and delivers bite-sized moments of pure gold, so you can benefit from years of legal know-how in just minutes. Each week, we bring you the things that make the big difference, so you know how to approach your legal situation with confidence and clarity. Now, here's your host and founder of the law firm Authority Network, Grant Eagle.
Welcome to the show, everybody, and I'm here with Senen Garcia, highly experienced business and real estate lawyer and founder of the SG Law Group based out of Miami, Florida. For over a decade, Senen and his firm have helped businesses and property entrepreneurs with a wide range of issues, including contractual negotiations, property insurance claims, as well as tax, and a multitude of real estate matters. In short, if you head up or run a business, or you're involved with real estate investment, you want to listen to what Senen has to say. Welcome to the show, Senen.
Thank you, Grant. Great to be here.
It's good to have you. Now, we were talking before the show about a multitude of things, but one of the things that stood out in our conversation was contracts, and you wanted to sort of share some insights with our listeners. And one of those really was that you see people skipping the details, right?
Exactly. You know, one of the things obviously is everyone, they recognize if, for instance, I'm here to provide a service and then you're going to pay me for the service, they figure, well, that's a contract. And unfortunately, that's not where it begins and ends. And maybe where it begins, but you have to consider a lot of other factors, such as what happens if things aren't done or completed, or how they're supposed to be completed, or by when they're supposed to be completed. And what happens if, someone doesn't fall through with their end of the bargain? What are you going to do? And how is it going to happen? And what penalties are there? So, these are a lot of considerations and have to go into effect. And, everybody obviously hopes that everything goes through. And usually when you're entering into an agreement, you're not expecting the other side not to follow through with their end of the deal. But unfortunately, more often than not, they don't. And you have to protect yourself in those situations. It's really like a Murphy's Law scenario.
Yeah. Just to sort of emphasize to our listeners, one of the things you mentioned to me is people have this tendency to want to try and take the easy route when it comes to putting a contract together, which is why you've seen a lot of people use websites that sell these DIY contract forms and things like that. Can you just explain to our listeners why that might not be the best route to go?
Well, it's quite simple, and it goes along with trying to keep it simple, thinking it's easy, and at the same time trying to save a few bucks. The problem is a lot of these form contracts, they are just that. They're a pre-designed form for a business, but they're generic. They're not akin to whatever specific terms are in your agreement. And make no mistake, every agreement, it's completely different than the next one. There's going to be some similarities, but there's going to be just as many differences, and you have to factor those in. And a basic example is I had an individual who was a client. He ended up getting into an agreement, downloaded a contract from a website, and the contract had clauses that were statutorily codified in California, which would be great if either party, let's say, was in California, but both parties were in Florida.
Right.
So he ended up having to spend a considerable more amount of money than he had anticipated overall, because the other party, again, didn't follow through with their end of the deal, and now we had to litigate. So it ended up costing him more in the end than if he would have just spent the money and done it right the first time. To me, contracts are like businesses. Everything starts with a really good foundation, a good base. And when you're entering into a contractual relationship, that base is that contract, that agreement. If it's strong and it's clear and it covers every details, the chances of problems happening are minimized. Not eliminated, but minimized. But when you have a faulty contract, you're already, on bad footing, and you could run into some problems.
Well, you mentioned to me that a contract is an enforcement document, but the other thing you said was, but you need to know what to enforce and, more importantly, how to enforce it.
Exactly. As I mentioned, one of the things that, when you get into a deal is you're trying to figure out what it is, you're providing, you're asking, let's say you're performing a service or you're seeking a service. you need to know what specifically that service is, because unfortunately, and it goes back to the basics of communication. You're encoding and you're decoding. You have an interpretation or a perception of what you believe is considered service that you're expecting, and the other parties also have a certain level of expectation. But if you don't put that in specificity in those agreements and factor in other things that you may not consider, then you have a situation of what exactly are you enforcing? Oh, well, you're enforcing probably some pie in the sky scenario that was never contemplated by the other side. And now you have a situation where you may not even have a meeting of the minds. You may not even have a contract to enforce.
I mean, it's interesting with contracts. I mean, I've seen it in my own business in the sense that sometimes a contract, when you're in negotiations with somebody else, can sniff out what the other side is thinking by just putting certain clauses in there, right?
Well, I mean, yeah, they can, but that's the beauty of when you're sending a contract is there's always going to be negotiations. So there's going to be a situation where they might say, oh, well, you're trying to put this in because you think, classic example, you want to put an arbitration clause in there because you're going to breach and you're going to make me spend money in arbitration versus court. And that may or may not be the case, but the beauty is it's business. It's, you really don't want to take things too personal. Every side is trying to protect their side to make sure that things happen. They're not trying to really, in the end of the day, take advantage of the other party. They just want to make sure that if situation goes sideways, they have repercussions in place that can protect them. And that's one of the things you have to go in with a mentality of going into an agreement. It's a negotiation, until you sign, things are still up for discussion. So if you don't agree with the specific term, now some sides may say, you know what, this is a non-negotiable term. We need this in here to protect our interests. And then at that point, you have to decide whether it's worth it or not to continue forward. Sure. But ultimately, recognize that both sides are just trying to protect themselves. And if you can come to an agreement, which again, another reason why you may want to get an attorney involved because they're experienced in this, you'll end up getting that agreement that you're looking for.
I think one of the other great benefits that sort of people might not realize, listen to this, of using an attorney is not just to protect themselves from, serious harm, but also it acts as a buffer between the two parties. So if you're doing a negotiation, it can get quite personal if things fall into disagreement. Whereas if you've got an attorney, it allows you in some ways to use the attorney as a buffer for the relationship, don't you think?
Oh, I completely agree. In fact, I've seen that happen where I had two friends that, wanted to get into an agreement. They wanted to start a business. And because I was involved, and of course the other person had an attorney when I got involved, the two individuals didn't have to get involved in the nitty-gritty of going back and forth. All they had to worry about was, we have an agreement, we've signed it. Now, at the worst, I would communicate with one of the partners and let them know, and they would communicate with me. But there wasn't this animosity of back and forth negotiation, and it allowed for an ease of entry into that agreement. And another point regarding the attorneys, as when I was an intern at a law office many moons ago. And, the attorney that I was interning for, he had a very good point. He says, attorneys are also insurance policies in and of themselves, because they really protect you. If something goes awry, they can see it before it happens and be, your other eyes and ears from a standpoint that they've seen these documents more often than not, and they can catch things that you may have not seen. So it's really having an attorney is a way to distance yourself, as well as protecting you in certain situations. And then, of course, there's the old adage, I don't know if you've ever heard this one. I found it funny where they would say, if you represent yourself, you have a fool for a client.
It's true. One of the things I also wanted to touch on is, again, people don't know what they don't know. And, there are you alluded to a few when we were talking off air. There's a multitude of little known facts that can trip people up along the way, in not just in contracts, but just making poor decisions because they believe one thing to be true when it's not. I mean, for example, you mentioned S corps, right?
Right. So, one of the aspects of S corps that people don't realize, and it's not a bad thing, it's just that they need to be aware, is that S corps are not a legal entity. When you're an S corp is a tax election. It's to help your entity, presuming you meet the prerequisites, to reduce or eliminate certain tax levels. So you don't have to worry about paying that additional liability. But it legally doesn't have any significance. And, ever since 2003, you can be an LLC, for example, and have the benefits from the legal standpoint of the LLC, but still be an S corp for tax purposes and get the tax benefits. So, I say that because, there's a lot of companies that I know that are LLCs, and there's really no reason for them not to be an S corp. And then when I ask them, I don't want to be an S corp because then I'll lose my LLC status. And I go, one has nothing to do with the other. And, they're actually hurting themselves financially because they're having to pay self-employment tax on all their profits that had they had set up an S corp, that wouldn't happen.
Mad. It's just, we just don't know what we don't know.
And there was just one thing that I've noticed this recently a lot with individuals that especially they want to sue people, is they have this misconception that if they win, they can get attorney's fees. And I tell them, well, in the U.S., because different countries have different rules.
That's true.
In the U.S., the American rule says that each side is responsible for their attorney's fees, absent a clause in the agreement that allows for the prevailing party to have attorney's fees. And that's another kind of thing. If you don't know, you don't put that in the contract. Guess what ends up happening? If you try to go sue, you can go ahead and sue, but you're going to be on the hook for the fee. So it may end up costing you more money to even sue.
Or you sort of, because you didn't put it in, really can't afford to,
Yeah, exactly.
Yeah, it's huge. So to wrap up, if someone's listening to this now, they're in a contract negotiation or they've got another issue when it comes to their business and they want to make sure they're going to do the right thing, what would be your advice to them?
Well, it's two parts. One is the kind of the obvious, is get it in writing. There are no such things as handshake deals. Get it in writing, be as specific, and definitely consult with an attorney. Make sure that everything that needs to be and should be in that agreement is in that agreement and that it is akin to what your deal is about. Otherwise, again, it goes back to the analogy that I gave earlier. Otherwise, you may be on faulty foundation and it could be a rocky situation should things go sideways.
Yeah, it's a great way to phrase it. Listen, Senen, look, thank you ever so much for coming on today. I know how busy you are, and it was great to have you. Now, for everybody listening to the podcast, Senen's details are going to be straight underneath. You can click there, go straight through to his website, and I'm sure to say you'd be more than happy to take their call, Senen, right?
Absolutely.
All right. Listen, thanks again, Senen. And as I say to all our guests, hopefully we'll have you back on soon.
For sure. Thank you again for having me on, Grant.
That's a pleasure. Speak soon.
Thanks for joining us in this episode of 5-Minute Legal Insights. If you'd like to contact our featured guest, just check the highlights on their episode page at www.legalinsightspodcast.com, and you'll find their phone number, email, as well as their website. Oh, and if you're a lawyer with something to say, then just get in touch. 5-Minute Legal Insights, helping people get clear on their legal issue in minutes. The views expressed by the participants are their own and are not endorsed by 5-Minute Legal Insights. Nothing said in this podcast is legal advice for you.